and I. I know.
So not according to what I want. It's not here. Rise to join me in the pledge of allegiance. Live on both. Okay, welcome everyone. Now is the time specified for the city council to conduct a public hearing. The purpose of this public hearing is to consider the following matter. Consideration of file number 01-2025, adopt an updated comprehensive plan, replacement development code, and zoning map in accordance with the technical assistance grant received from the DLCD. The substantive criteria upon which the city council will base its decision in this matter are contained in 7-1-6 plan and implementation measure review and 7-1-7 plan amendment applications and 7-1-8 plan amendment, 9-1-6 zoning and development code administration amendments, 9-1-7 condition for granting amendments, 8-1-2 subdivision administration amendments. A public hearing is required by law and certain rules apply. First and foremost, you must be recognized by the chair in order to speak and present testimony. When recognized by the chair, please proceed to the microphone and state your name and address for the record. The hearing is required by law to be recorded. Generally, the public hearing process is as follows. Prior to the public hearing, a determination will be made of the qualifications of the council members and allow for challenges from the audience. I will open the public hearing with a staff report. The purpose of the staff report at this point is to further identify the applicable criteria of the case being considered and to provide background information about the case. Next, there will be testimony from proponents, those persons in favor of the application. Next, there will be testimony from the opponents, those persons not in favor of the application. Next, there will be testimony from anyone else who wishes to offer testimony or ask questions. Then, to honor the right of rebuttal, we will again hear from those in favor of the application. To expedite the hearing, the council members may ask clarifying questions of persons as they testify. When this process has been concluded, we will close the public testimony portion of the hearing. During the hearing, some important standards apply. First, those who testify must hold their testimony to the decision criteria. As in all land use hearings, there's a complete set of rules, procedures, and criteria we must follow. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the council members and the parties an opportunity to respond to that issue precludes an appeal to the Land Use Board of Appeals based on that issue. Third, the failure of an applicant to raise constitutional or other issues relating to proposed conditions of approval with details specific enough to allow the city to respond to the issue precludes an action for damages in the circuit court. Fourth, prior to the conclusion of the public hearing, any participant may request an opportunity to present additional evidence, arguments, or testimony regarding the application. If such request is made, the law states the council must grant the request by either continuing the hearing to a time and date at least 7 days from the date of the initial hearing, or the record must be kept open for a period of at least 7 days. These are the rules. Have any members of the council had any ex parte contacts, conflicts of interest, or bias? Maria?
No.
Jesse?
Conversation last week. Land use. What's that going on? Is my question.
You guys speak into your mic.
Sorry, move your mic closer.
Folks on the video, I can't hear you.
People
I haven't turned it up.
Some people zoning, that, and use, want to know what's going on.
So would that prevent you from rendering an impartial decision on this matter? Janie? Tammy?
Questions that are asked.
Would that prevent you from rendering an impartial decision on this matter? I've had the same. I've had phone calls and questions regarding the comp plan and their code, and it would not prevent me from rendering an impartial decision. Verlaine?
I've had questions and text messages just asking about when the meeting is and all that. So similar, but yeah.
So would that prevent you from rendering an impartial decision on that?
I think also you need to have a potential conflict every meeting.
I did it all at once.
Oh,
I'm sorry.
I'm like around. Okay, my thank you. So and the interest is that a family member owns a property that could be rezoned.
Same question as far as,
It does not affect how I will vote and speak on
okay, very well. Richard?
it.
No. Okay. Does anyone in the audience wish to challenge the qualifications of any members of the council? Seeing as there are none, we will move on. And at this time, I will open the All right, at this time, I will, the public hearing is now open. And, now we need a staff report. So Dave, I'll start with you.
So I'm going to address, not the memorandum, but I'm going to address things that was requested to do. The last meeting, one was to research and talk with the county tax department, Rachel Reynolds. I did that. I sent you out a copy of what she sent me. Our phone conversation was kind of a reiteration of what they do. So basically, in a nutshell, from what I presented to you, that will be part of the record for the minutes, is that they use state statute. I made a copy of that. I actually, because her email had the state statute in it, but I couldn't make it work in print, so I printed it for you, and then I also emailed it, but I also went to the website and got that statute so I could put it in a Word document so you could actually read it. And she laid out that the criteria that the county uses for tax assessment is this in the statute 150 or OAR 150-308-0240 is pretty much, I guess, more or less their assessment Bible that they use for all tax assessment for anything that they do for tax assessment. As far as the commercial versus residential, as she stated in the email, she said, per our phone call conversation, I want to follow up with the Oregon administrative rule to follow that we follow when we determine the real market value. At the bottom, she says, keep in mind that in the middle of the substance is just the statute. Then she said, this is from Rachel Reynolds, our the main tax assessment manager for the county, Umatilla County. Keep in mind that if a zoning is strictly commercial, we most likely will put a commercial land value on the property, but appraise the home as a residence, not a commercial business. So she was very clear about the distinction between the two, and or if, then we also talked about language within zoning, which isn't her expertise. Taxing is, she's stuck with taxing, but then they would, you know, depending on how that is property is used, they use that as a part, as in the statute, they use that as part of their criteria.
So
And
it's
not
assessed based on the fact of its use.
Correct.
Not necessarily.
correct.
And I read those OARs, as fun as they are, and that seems to be the case.
Yeah, and she and I talked about it a fair bit, and she was very black and white about it as far as this is what they do. This is all we do. We don't follow any other thing. This is what I send out with the assessors when they come value property. So those two guys that were running around town the last 3 weeks, this was what they were using. So, do you have any questions about that real quick? This is my staff report. So yes, ma'am.
I'm not sure, I just want to make sure I understand. So if it's a residential home, it will get taxed as a residential home.
That's what she said.
The property that residential home is on will be taxed as.
Might, maybe, sort of. They use it as, this is where I love talking with attorneys and tax folks. They don't give you a black and white answer on everything except if it's in statute. So she said, and you go call her, talk to her, everybody in the room, call and talk to Rachel. She'll love to talk to you. Took me a week to chase her down. She's a busy gal. It could be. They look at a piece of property and they go, well, what's it zoned? Oh, it's residential. Is that the best use for this property? They actually make those kind of determinations while they walk around and do their tax assessment. So they'll look at it, and if they look at one of these places on Bridge or on the way she explained it to me on the phone, she didn't explain a lot in her email, obviously, or over here on Sprague or Water, is that they'll look at it and go, best use, yeah, house, best use, tax assessed as a house, resident. And so that's how they kind of go about it. It seems like it should be black and white, but then she kind of made some gray by, well, what's the best use for the property? And then that's the kind of a criteria that they check. So that is as clear as I could get from her that's why I had her give me this statute number so I could go read it as well and kind of get what their main criteria are. And so it's being used as a house. That's the best use of the house. It's been used as a house. The language says it continues to be a house till the end of time, and that's how it's assessed.
And I think it's only assessed at a commercial land value if it's only zoned as commercial. If it's zoned commercial residential, it would be different.
And that was kind of what she was leaning towards, but she wouldn't, yeah, strictly commercial. But then again, what was brought up before, that if somebody Mrs. Fife brought up a good point several meetings ago about the FHA loans and the concern that was for some folks, and it's a very valid concern. But that gets addressed from the loan officers as far as the language. They'll go, is this property allowed as allowable use? What's the allowable use? Because when they do that, they look at the allowable use. So they're looking at it from a different lens at the same thing. That's why land use is so confusing. So, because there's different lenses for different views that we, as average people, we don't do every day.
I think another distinction that you need to understand is that if you go home and you dig out that statement, you get once a year from the Umatilla County Assessor's Office and look at it, it's gonna tell you that they've assigned a real market value. That is not your assessed value. And so the real market value takes into consideration what the market might bear. But the assessed value is based on any number of factors, including the factors in Oregon around Measure 5 and Measure 50, which absolutely confuse how assessment is done. And as a planner, I've made agreements with every assessor I've ever worked with that I will give assessment information if they don't give planning information. But I think it's important to understand that when you go look at your tax statement, you're going to see two different things. And what she's talking about is that from a market perspective, they may very well look at that property as commercial property. Because if it's zoned and can be developed as commercial property, then from a market perspective, they're going to look at it as having that market value. But the assessed value is going to be what is actually there and how it is currently being used.
Yeah, that's better than the way I explained it, but that's exactly what she said. So does that clear that up, Councilor Williams? Okay, so I'll move on to my next assignment. That was to talk with irrigation districts. Caught up with Brian tonight from Stanford.
While we're on that subject, do you want to address the mortgage stuff since that was brought up, or is that later in your?
The mortgage.
Right, you were gonna contact a lender.
Yeah, that didn't get done. So I apologize for that. I saw that on the list and thank you for reminding me. I didn't get through that. So.
Okay, sorry,
No, I did not get that done. That's something that I don't think you guys are gonna approve anything tonight, so I'll put that on my next to-do list. Just to revisit my old list and find that and talk to a mortgage. I apologize for that. Moving on to the irrigation companies, I talked with Brian Anderson tonight right here in this room. His number one thing is life and safety, and that, you know, if we're gonna do anything around the ditches, that, you know, of course, the contractors need to talk with them and they need to be lined. I met with Annette Kirkpatrick last week, went to her office in Hermiston. I think we had a pretty good conversation. I'd like to think so. We talked about a number of different topics. One of the things that came up was that I brought up and we talked about, which is Goal 7, Section 4 policy statement in the comprehensive plan from 1978, 2005, and what is currently still in the proposed right now, states that, I'm going to read it, we've read it multiple times, but I'm going to read it again. It says, this is on Goal 7, and it says, in Section 4, it says, in our policy statement, it says, to protect the city from possible overflow from or damage to the feed canal or furnished ditch. That seemed to give Annette some pause, and she could speak on it. I'm not going to speak on her behalf. She's here. She wishes to speak about it. That's not something, the ditches are not something that the city manages or maintains or operates. So it was a bit of, I felt like I received, it was a bit of a concern of hers. So then I followed up from that and went to CIS, our city insurance services, our risk manager, and Lisa Masterson, and then she put me in touch with our city underwriter. And Jeff went on to talk about the fact that he felt that was pretty sketchy language to be in there because he felt that would put the city at risk when we don't manage, we don't insure it. The city's flood insurance only covers city buildings and city infrastructure, does not cover anything private. So if a ditch were to bust or leak or overflow and damage somebody's property, our insurance does not touch it. And they felt that language says that our insurance will cover a flood from that. And that's their interpretation, not Dave Slat's. That is CIS's in writing interpretation. So they were asking me to see if we could get that removed or reworded to make it so it cannot make the city at risk. So that was their concern. So, and then I also talked with Annette about my mistake about not communicating with her better over the last few years. And I wanted to be really clear with her is that a lot of the project work that the city had been doing had to be cleared with the Bureau of Reclamation. I should have talked to Annette more, and I apologize to her. However, the engineers had to work with the engineers, and they made the decisions that none of us could make as far as the design work to cross, go under, go over, do around the ditches. And that was probably the main reason, the lack of not communicating with her office the last few years, because most of the stuff that had to do with that was our infrastructure construction. So again, that falls on me for not being better about communicating with some of these local agencies, but we weren't making any decisions or doing anything that were gonna cause issues with that as far as we don't have, that had to be done through the engineers. The Bureau of Reclamation has the final say on the ditches as far as what the engineering, the structure, and HID manages the water and their other responsibilities. And SID has always been really good to work with as far as if we got to cross, then we got to have an engineered plans. The board's got to look at it. Brian's been very clear. Before that, Mr. Kopax is very clear about certain expectations when operating or being around those ditches. So that's my experience as your city manager working through that. And those were my conversations. And I hope that I covered that well with what Annette and I talked about as far as pertinent to what tonight we're talking about. There were other subjects we talked about, but they aren't pertinent to tonight. I think that was probably the majority of what I was asked to do as far as going and getting the research done, except for the mortgage thing. And I apologize again for that. I did notice in a number of, this is kind of a separate thing, but it is directed at staff quite frequently throughout this process that in comments made in public comment and comments made by some council members that staff that don't live here or have any buy-in city have some sort of are making decisions for the city. And I want to be really clear. I don't have any decision-making power except for day-to-day operation under your purview when you're acting as a city council. The contractor that you hired to do the planning doesn't have any control or decision-making power to do that. You guys are in control of that completely 100% in it. It's kind of getting to the point where I don't even want to have a conversation with anybody because it's always, we're going to be making decisions and I'm not making any decisions. I don't have that authority to do that. And I asked the council if you guys could at least back your staff up and not throw us under the bus because we're not making the decisions. And frankly, I'm tired of that behavior. I'm just tired of it. So that's all I have.
Well, I'm just curious on your question, Brian Anderson, it needs to be lined.
Yeah, so what he was very clear, and so was Annette, that if projects going around ditches, that they want them lined or some sort of protection for the ditches. And that's the first thing that they both went to is line. And I agree, aligning the ditches before you do anything to do that. I've already talked with Mr. Hatley's project manager that they're going to have to work with HID and obviously SID for the project in the south end of town for those homes, because there's water that goes in that field. There's nobody's going to deny that. So they're going to have to do something about that water, and we're going to put homes in there. They're going to want some sort of lining in that ditch is what I've been informed, but that is their responsibility to do, not for me to chase down. That is the contractors, because they got to work with the agencies to get approved for their project. And they will have to come before you, Tammy, in another hearing that's a public use hearing to do their development in the subdivision somewhere down the road. They're not ready to do that.
So if, do we need to have this someplace, I guess it's a Carla question, do we need to have this someplace in the comprehensive plan where it says the contractor has to meet with?
It's pretty straightforward.
You don't regulate in your comprehensive plan. You regulate in your development code, and frankly, the development code already has provisions that require them to obtain all other local, state, and federal permits
For residential.
for any development.
Residential.
So if anybody wanted to build between the canals, let's say that just happened somewhere down the line,
Mhm.
they would have to contact both Stanfield and Hermiston Irrigation District before they'd ever get a permit to build anything.
And so they would know that just because it says to contact all the utilities and that.
Correct.
Well, and in Echo,
All the agencies.
I tell them to do that. I mean, Madison has had to do projects up there, and then he put the culvert in to replace the wooden bridge at SID. He worked with Brian to go through that process to get that done, because they replaced the road off, going down off of Bowman, going down above there. So where we put a new bridge in, which I worked with Bureau of Reclamation to replace our bridge at the bottom of the hill on Bowman. The upper spot has a big culvert now. That was between Mr. Madison and SID to get that put in, to do away with that risk and liability of that old wooden bridge. So that had to be approved and gone through them. That couldn't have been done without their approval.
I would add that individuals who are building a house probably don't know all the things they're gonna have to do. And that's where staff play a really important role in having that conversation about what's required, who to talk to, how to have those conversations, who are the contacts. If it's a developer who's doing, whether it be a large subdivision that is a residential subdivision or a commercial or industrial development, those developers are pretty savvy and they know what they're doing. That doesn't mean that there shouldn't be good staff coordination at the point where you're having those conversations about what is the project. Something that most planning commissions, and again, I'm gonna refer to planning commission because most of the decisions we're talking about would, while you serve as the planning commission, they would be planning commission decisions. Most of those planning commission decisions, there's a lot of work that happens long before it gets before the planning commission for a decision. And that is having those conversations about utilities and what does the development code say? And do you need to do a zone change? Is there a text amendment that's going to need to happen? There's a lot of conversations that happen at the staff level long before a public hearing is noticed and a staff report is written and a public hearing is held. And those questions are asked and answered, and those connections are created. So if they're like, but I don't know who to talk to at HID or SID, your staff is the one who's helping them make those connections. Well, if you're gonna go talk to HID, you need to talk to Annette. You're gonna go talk to Umatilla Electric, you need to talk to, well, in some communities it's Monty Ellis, but he's gonna retire, so I don't know who it's gonna be at UEC. But if you're gonna talk about power, you're gonna go talk to UEC. If you're talking about water and wastewater, you're gonna talk to Dave and Scott. If you're talking about phone lines or internet lines, it's whoever your local provider is for that. So those connections are happening long before you see that application, and those connections continue long after that application is.
Yeah, I guess the reason that I kind of put that question out there because we did kind of seem to miss a step here with notifying the irrigation districts of this. And so I wondered, did we need to have it in the development code just to jot memory that there anything with an irrigation with any of the canals has to be, you have to meet with them. I mean, we have utilities, but we don't specifically name the irrigation canals, and that would just be a jot. If, let's say, Dave left, you know, and then the new person that's in doesn't know that. And so we're not communicating with them. That was my question, kind of, do we need to have a place in that development plan just to give a memory jot, so that, because not every place in the city, that's rare. I mean, there's a canal, but not all the houses have that. But you do with utilities and sewer and water, and those are listed, but not irrigation.
So, you know, every community approaches that differently. And I think what you're looking for is a process that just assures that you have staff who have a good process that they follow. Your code does not have to include every detail. If it did, your development code would not be 200 pages long. It would be 697 and a half pages long. So I think you have to have some restraint about what you include and what you don't. So I would encourage good process, and as you have good process, then those connections are going to happen.
Yeah, your city administrator could have a list of
Mhm.
any contact information. Office and say, hey, I want to build a house over here. Then they look at their contacts and go, oh, and they look at the map and go, okay, well, then you need to call this guy, this guy, this gal, and this person, and so on and so forth. And they've got it all, if they are a good employee, they'll keep that list up to date.
And the HID is also a BOR facility, so that also falls, do I have the right word? HID, is it HID is the federal facility?
Yeah, Bureau of Reclamation and HID.
So in that piece where it says you have to obtain federal permits, that's also going to kick in as well.
Automatically, because that's, as she brought up before. I want to clarify something very quick, Tammy, and I didn't mean to interrupt you, but I want to clarify something, because this was something that Annette brought up, she educated me, and I'm sorry that I forgot to talk about this, is that, one of the things when we were looking at the zoning maps, when all of us with the pack, and then when we were doing it on our own in GIS in the county, is we didn't see the ownership on the lower ditch, because the way I understood Annette, that it didn't get recorded, it's in there. She's got it, they've got it at the county, but it's on like the planning down, it says, I think she said 1917. And then talks about it, but they didn't actually record some of those ownerships on some of those areas throughout the region. So there's sections of the Bureau of Reclamation ditch that don't show a record on the tax lot that says who owns it. It just shows the ditch going through, and then the landowners that own both sides or parts or whatever. And I don't know if that's true for the whole system, but it's partially true for here. Now, SID, it shows where they do own some, and then where their easement, the easement's easy to find. And so that type of information. So that was our fault for not seeing something like during that. But it is easy to overlook. And Annette had told me that she's constantly been dealing with that throughout her time, because it's overlooked. And so it was a good education for me as well. Sorry, go ahead.
You know, I just, when I hear that, life safety, number one, is a first issue.
Mhm.
I don't think adding, to me, just to add your irrigation canal to that water sewer and, those systems, to add 2 words in maybe a couple places, just so we make sure that it's noted in our development plan. And then it would be noted, and then we would make sure that if it was necessary to be notified, they would get notified.
So
Just
make
like
a,
a catch, just a memory catch.
so make a note of that, and we'll talk about it when we get to the discussion part. Okay?
Thank you.
Berlin.
I just want to say, we talk about it at every meeting, that, no matter what the zoning is, there's a zoning change or not, the irrigation districts and ditches don't lose their access, their rights, or their ownership of the ditches. So it stays the same, they're gonna be involved. So I guess I just don't know why it's such a big deal. They're going to be involved. And no matter what the zoning is, they have the same rights.
Thank you, Berlin. Okay, David, anything else?
No.
So Carla, do you have anything?
I do. So there's go back a ways to an original hearing, there were 3 staff reports that were written, staff reports that were provided. And in them, it called out the substantive criteria, which Mayor Ray, I know you have mentioned every night. There's been a public hearing, but just as I'll kind of come back to what the process is that your decision is based on that substantive criteria. Just like if you were approving a conditional use permit or a subdivision, your current development code provides you with substantive criteria, and you evaluate the application against that criteria. So for each of those staff reports for the zoning map, the comprehensive plan, and the development code, that substantive criteria is in there. Staff provided a response to that. There's not been much discussion or testimony that has been provided. And I say testimony because there's really been no evidence provided. There's been testimony provided, but really no evidence, with some minor exceptions, that would address that substantive criteria. And that's what you're looking for, is what's the decision before us? Part of that substantive criteria asks, who was the applicant? Well, the city was the applicant. The city applied for and obtained a technical assistance grant to do this work, and this work required that we move into public hearings and move towards adoption of these changes. So there's other considerations in that substantive criteria. We could certainly go through those in more detail. Maybe I should have done that at the front end, at the first hearing. But I would just encourage you to go back and look at those original staff reports and look at that substantive criteria. That is what your decision is driven towards and by and from.
Thank you, Carl.
Mhm.
Anything else?
No.
So, it'd be probably the best procedure, Dave and Carla, to go through your memorandums in the discussion portion, is that correct? Or is now the time to go through those?
The memorandum for tonight?
Yeah, the public has commented and asked questions and addressed concerns or likes, dislikes. And I went through them last time, I think during the discussion portion. I would just want to make sure that
Yeah,
that would be the best time to do it.
Yeah.
Tonight.
absolutely.
Okay.
Yes, however you want to approach that.
Okay, very well. All right, anything else from staff? Okay. Okay, so at this time, we'll open it up to public testimony. I do want to remind folks that you'll have 5 minutes, and my time is gone. My ticket. Excuse me while I get. I also want to remind everybody that we're looking for specifics. There's something specifically in here. That's what we want to hear about. Generalities and things, just as Carla said, aren't really what we're expecting tonight. We're expecting you to say, hey, I don't like this thing on this page that says I have to have an 8-foot fence or 2-foot fence or something like that. So, so please keep it to the matter at hand and be as specific as you possibly can. And that also, I want to remind everybody that the following will not be tolerated at any time during the meeting: yelling, name calling, profanity, disruption of any kind. If any disruption occurs, you will be asked to refrain from that behavior. And if you continue to disrupt the meeting, you will be asked to leave. So we haven't had much issue with that, but just a nice little reminder. It does a lot of passion in the room. So. Oh, no, okay, sorry about that. So does anyone wish to testify in favor of the application? Yes, ma'am. Please approach the podium and state your name and address for the record.
Hi, my name is Joan Sonnenberg, spelled Sonnenenburg. I live at 8 Smith Drive in Echo. Okay, so I'm here tonight as I've lived in Echo now 14 months, and I feel very honored to be able to come to these meetings and give input. I was at the last meeting and I felt I needed to know a little more about what was going on. So I did take time just to let you know to read the red line planning document. And I recommend the adoption of the proposed plan because I find it thorough, flexible, and with built-in safeguards with a 20-year growth focus that focuses on urbanization, economic growth, as well as balances out Echo's belief to support our natural resources, our historic significance, and the people that live here. The updated plan has expanded the language of the current plan by providing historical context and clarification. Last week, last meeting, someone said we don't need to change the plan at all. I found that the updated language, and one reason I supported it, is that it did provide more clear guidance as well as policy statements that tell how to implement the plan, how it will be coming to effect. This was demonstrated through the housing zone class, as well as folding in the transportation system plan into the comprehensive plan. So that's another reason I'm in support of this plan. Specifically, I want to acknowledge that the implementation of the comprehensive plan will require compromise and evaluation to ensure the intent of all the goals that are outlined herein are balanced against and with each other. Many of the goals that you have outlined in this plan, which is a very good plan, will have conflicting agendas and people that will have different needs during the time as you implement this plan. I would like to address goal number 5. This, as I was reading through your minutes from your different meetings that you've been having, as well as discussions, goal number 5, to those of you that may not remember, is the goal that addresses natural resources, open spaces, scenic and historic areas. This, when this plan is adopted, I recommend that a subcommittee be established to do what that plan outlines for this goal. And I'm going to say right now, I volunteer to be on that subcommittee. For example, this goal has specific policy steps I want to bring to your attention that are maybe in conflict with what's currently going on in the city. The goal number 1 is to identify open spaces, scenic, cultural, and historic areas, natural resources which should be reserved from urban development. The word there says form, not from, so I think that should be changed. Actions, and then it goes on to say that was old language or current language. Proposed language describes how this should be implemented. Actions to achieve this policy include encouraging multiple uses of compatible open space land, applying protections to wetlands to protect them from destruction and incompatible uses and to preserve their hydrological and ecological functions, and working to conserve areas' natural resources. Goal number 3, to preserve the existing ecological pattern of open space and drainage ways through land use public acquisition of suitable land by requiring dedication of adequate open spaces as part of development approval, either via land donation or payment in lieu. And then the last one, number 6, is to conduct a thorough community-wide inventory to amend the development code to protect identified archaeological historic sites, historic structures, and artifacts based on current historic sites. The outcome of this should be a historic preservation component of the development code. So of these specific goals, the current land use map does define certain open spaces, but those open spaces do not belong to the city. So we are in conflict here with some of this language. If those open spaces on the map need to be included as part of this code, then those need to be purchased by the city in order to name them. And then they need to come under open space use, which means it needs to be publicly accessible to all the citizens of Echo, as well as use. And then the use of that land needs to be well defined, so the citizens of Echo understand what the public use is. Is it a park? Is it a walking trail? Is it a place to go nude sunbathing? I don't know what you choose. You may want to use what we may want to use it for, but we need to publicly state that, and then that land needs to be owned by Echo. Right now, I don't see where we can, I'm in total think this is great, but I think we need to be clear and remove the conflict between our map of open spaces and how those are zoned, as well as what this document says. Thank you very much, and again, I volunteer.
Thank you, Joan. Okay, anyone else wish to testify in favor of the application? Yes, sir.
I'm Kent Madison, MADISON, 28647 Madison Road, Echo. And I wanted to clarify, you all received a letter that was addressed to me from Jennifer Bragger. I want to know how, I want to clarify why you guys got that. I had a relative that was interested in acquiring some property up on the golf course hill, and he looked out across there and saw the sagebrush down below and said there's no way in heck he would buy property on the North Hill or the golf course hill because of the fire potential. And with the fire department on this side of the railroad track, that really concerned him. And I got to thinking about that. I thought, well, you know, that's a pretty good observation. I never thought about that myself, but who's the liability? Who holds the liability of that sagebrush covered ground that's basically on your map as open space? And then it got to me thinking about the wildfires that are in California and the other wildfires we've been seeing around the country is, you know, it's nice to see brush covered land until it's all on fire. And then the question becomes who's liable for that. So I called up Jennifer Bragger, who's a friend of ours and the attorney, and asked her, you know, who would be liable if there would be a fire in this open space? In other words, if the public designates a zone as open space on private property, who holds the liability to it? And she says, it was interesting. Her question to me was, well, what's in it for you? What are you trying to figure out? I says, I just want to know the answer. I want to go to you folks and tell you what an attorney would say if you were in front of a judge before we end up in front of a judge and the attorney tells you what you should have done. And so that's what this letter is about when you read through this. And as you read through that, it looks like it's really quite a mistake to have, you know, privately owned land zoned as open space because your code doesn't allow the uses necessary to maintain open space from a fire prevention standpoint. So your code conflicts with what you would really want done, where if that code was if it was zoned in something like residential, or industrial or whatever, anything other than open space, you have codes in your plans that say you have to control your weeds, you have to do things to protect the fire from other surrounding neighbors, but you don't have that in your open space code. And also, as you read through this, you'll notice that open spaces, you know, typically only applies to publicly owned land, not to privately owned land. And in your code, you also specifically state that open space is for flood zone protection. And it's in the flood zone. And as you well know, the stuff between the canals is not in the flood zone. And the map on the back clearly shows that. So then it got me thinking, and I guess the attorney in the room can hopefully answer this question is, if we're going to impose onto the citizens of Echo, the landowners of Echo, a zone that we know has liability risk associated with it, that they can't control that liability risk because of your codes and your standards. If something were to occur, a wildfire were to occur, are the members of a committee who voted for that standard knowingly knowing that it's wrong, would they be liable? That's the next liability question that I should have asked my attorney. I don't know what the answer to that is.
I think their votes in their official capacity as council members would lead to liability of the city as a whole, but not individually.
Okay.
There's no malfeasance or necessarily, but they're just acting in their official capacity.
Okay, so if the committee was to vote for something that would increase the liability to the city, then you're saying that would probably put the liability on the city in that case.
That's correct. That's
Okay.
correct.
So that's my concern, guys, is, you know, we're all trying to make Echo better without a doubt. And we all see places burn up and everybody points their finger at everybody once those places burn up. And I wanted to not have the finger pointing to start with. We know that if we keep those in open space, that we're putting the private citizen and the city at liability risk. And I really hate to see you do that. If you change the zoning to something other than open space, then you have codes that say you have to control your weeds, you have to do this. And probably your worst case scenario, in my opinion, is if you leave it in open space, which your code currently say you can do agricultural, you can do other things, including livestock grazing, which is not a bad thing if you have open space down on the river bottoms, but you probably don't want a bunch of cattle and goats running up there on the hillside Because that would really be about the only way under your code that they could legally control the brush to reduce the fire risk. And I don't think that's what you want to see happen either. That's perfect time. Thank you.
Thanks, Ken. Okay, anyone else wish to speak in favor of the application? Okay. Okay, does anyone wish to testify in opposition to the application? Gina, come on up.
Gina Saylor, 33229 Mark Street. I wanted to start by saying with the open space property being on private property, it is common in Oregon for it to be on private property. Examples of it in many cities in Oregon, Bend, Eugene, Salem, they have it in creeks, along creeks, irrigation ditches, steep slopes, or unstable soils and habitat corridors. So it doesn't have to be open to the public. It's more for the safety. But that being said, I'm gonna go ahead and read what I'm. The more I read and investigate the proposed comprehensive plan and zoning changes, the more uncomfortable I become with the direction being taken. It saddens me that this process has become contentious, but the reality is that the trust has been deeply eroded. Many members of our community no longer feel that their voices are being heard or represented. In an article by the land use expert Randall Arendt, he writes that local officials in our rural and suburbanizing areas face a critical choice, whether to continue using conventional zoning models or to refine existing land use regulations in a way that prioritizes open space and preserves rural character through thoughtful, creative planning. He describes conventional zoning as a blueprint for development alone. That does little to preserve what makes a place unique. Arden notes that conventional zoning designates almost every acre for development, residential, commercial, or industrial, with only undevelopable areas being floodplains or wetlands. That sounds strikingly familiar to the plan being proposed for Echo. This type of zoning has been called plan sprawl, and with good reason. Every square foot becomes front yard, backyard, driveway, and street. There's nothing left to preserve open space or rural identity. It won't happen overnight, but it will happen. And if this plan is approved in its current form, that slow erasure of what makes Echo special will be this council's legacy. What's most confusing is how we got here in the first place. Several committee members, Tammy, Jesse, and Vicente, clearly expressed their desire to keep Echo a small agricultural town with minimal regulatory change. Their emails on the City of Echo websites reflected what most of us in Echo believe. We don't want our hillsides filled up or every corner of town transformed. Vicente rightly raised concerns about unnecessary new regulations and broad zoning changes. Jesse's email couldn't have spoke more clearly for what I see for our town. These three members were clearly in touch with what long-time Echo residents value. Jay's comments, in contrast, felt disconnected from that shared vision. So again, I ask, how did we end up with this plan? It feels like the original mission to keep Echo small, rural, and authentic was lost along the way. I don't know who Carla is working for, but it isn't the citizen of Echo. I don't care how many years of experience she has, the plan she drew up is plainly favorable to developers, not to the people who live here. It put nearly every acre except for floodplains into buildable zoning. How is that preserving rural character? How does that reflect the will of the community? It gets worse. Residential zoning was extended between the ditches without any consultation with the ditch company. She should have known the ditch company should be involved in rezoning. We've had ditch breaks without building. People in residential commercial zoning were going to be automatically placed in full commercial zoning with no outreach or consideration of how it would impact them. This should stay zoned exactly as it is. The golf course and the school, both key public assets, were zoned residential despite no clear reason or plan to develop them. Why zone them at all if there's no intention of building? I believe the present council administration have no intention of subdividing the golf course, but if you leave it zoned this way, might make sense to future administrators or counselors. The golf course needs protected. Finally, there's the issue of outreach. A couple of $1,000s were awarded to the city in a grant meant to increase community involvement. That could have easily covered mailers to every household in Echoes. A simple, effective way to let people know what's happening. That didn't happen, and the lack of outreach and transparency has only added to the growing distrust. I believe this entire plan should be voted down, keep the current zoning in place, make only the changes that are required under Oregon law or statute. If a developer wants something different, let them come before the council and make their case through the standard process with public notice and input. That's how it's supposed to work. Echo doesn't need to be reimagined. Most people here are happy with the town as it is. What we need is a plan that protects what we have, not one that prepares it for transformation. Thank you.
Thank you, Gina. Okay, anyone else wish to speak in opposition? Okay, then we'll move on. Does anyone wish to?
You have letters that you can
I
either
would
bring
love to go
in
through that.
or vote in, or however you're gonna do
Okay.
that as we talk about the meeting.
Okay, thank you, Dave, for trying to do that. So there are several letters that have been submitted. This is some of them. And some of them are over here. Most of which don't address anything specifically in the plan. They've all been delivered to the council, so the council has been able to read them, and so they're fully aware of what's in there. I was wondering if it would be okay with the council to have a vote to just enter these into the record so that I don't have to read them all tonight, so that they can be posted for the community to read. But in the essence of time, and there's so many, it's gonna take a good hour to probably read them, I'm guessing that half hour.
Yeah, I would encourage you to, the letters that have been provided, there was another one sent later this afternoon. And then also the letter that Mr. Madison provided from Jennifer Bregger should all be included, because he did not read the letter into the record. He talked about it,
Correct.
so that one should also be added to that list of things to add.
Yes. If you want, yeah, go ahead, Tammy.
People took time to write that letter, those letters. They should be read.
I think it's the record.
And I thought it was.
There are.
There are all these,
Yeah.
there's a few that came today, because that's when the Vicentes was turned in 2 hours before the meeting.
I don't think it's a good idea. I think that's that's kind of maybe a non-trust issue when somebody writes a letter to the account for the meeting and they can't be here, it's not read.
So it would be part of the record, and everybody would have the opportunity to read it, whether they're here or not. So it still achieved the same purpose. The council is really the ones who have to deliberate on those letters. But I see your point. It's just, I don't know if everybody wants to sit here that long, in the essence of time to get it in. There's nothing in the law that I know of that states we must read them. They just need to be entered in the record.
As long as they're made part of the record and they're posted with all your other materials that are made part of the record with public access, there's no problem. Because we give people an opportunity to review those and come before you if there's another meeting to respond and further comment on it. But that is a decision of the council.
Correct. Yes.
They're all against, they're all about the ditch.
Except Mr. Madison.
Except Mr. Madison's was he was neither for or against, it was clarifying.
Correct.
Yes, so that would be,
it'd still be a matter of the record, Mr. Mayor,
yes, no, definitely part of the record. But it would
and then
be,
made public on the website and wherever people want to read it.
yeah, it would be neither in favor nor against, or against.
Correct.
Yes. Not right at this moment, that's, if you'd like to testify, you can, but
Sure. We're still in the against at the moment. You haven't gone. to the
we're
next
still
one.
in it, Phyllis, we're still in the against.
All I want to say is that I know my husband sent a letter and it's not.
Oh, no, that
Yes, I
was,
already talked to him. It was, we'll talk to him. It wasn't in for this, it was for the general thing.
Okay. And then.
sorry, thank you.
So I would like to make a motion that all the written testament is entered into the record and not read tonight, but it will be available to the public and everyone to read.
Oh, second.
Okay, so Berlin has made a motion to, enter all the written testimony into the record and make it available for the public, to review. Richard has seconded that. Oh, Maria, your vote?
Yes.
Jesse, your vote?
Yes.
Richard, your vote? Berlin, your vote?
Yes.
Tammy, your vote?
No.
Janie, your vote?
No.
Is that a no vote or a yes vote? So, the votes are 4, and 2 against, motion carries. We'll enter those into the record, and Janie will get you, numbers, so.
Whenever you get posted, they'll have the numbers on it, Jamie. It'll say 25.
Okay, thank you, council. Let's save everyone a lot of listening to this.
They still have the neutral against.
Oh, I'm sorry.
You got them. I don't have them. You have them all.
I'll figure it out by the end of the meeting,
Okay.
so that it is on that record.
Okay.
Okay. Yeah, we can get that, just give me some time. I'll count them. And then I'll have Dave double check them so that we don't miss anything. Okay, so, does anyone wish to testify that is not in favor or in opposition, or would like to ask a question? Yes, ma'am. Come on up. That was not your buzzer, by the way. It's a short 5 minutes.
I'll make it short. Everyone will take Katie Rommel, 330 West Wilson. So just listening, going about things. There's still one thing I brought it up a couple weeks ago or a couple meetings ago about Gold 10 on the housing. I did mention a letter, which I do have that, so I can send that in as proof. So this just goes about the permits and talking about how Oregon is 45th on 50, so we're basically rated F for moving here and the housing permits. And I did bring up that on the state website under Gold 10, it does say that we should do a housing needs survey. And I would urge the council and the city to possibly conduct those or conduct one of those because I know we haven't really gone into like chapter 2 and the codes and the housing and everything that's coming in, but we've got lands that's up for sale and for development, and lots of rumors going around about the Snow property. Recently, it's been a lot of manufactured homes now are going to be put there. So I don't have anything against manufactured homes, but if we're trying to promote growth and sustainability in Echo, I don't know that putting in a whole development full of manufactured homes is the way we want to go. one, we all know they don't hold their value, and two, they're extremely hard to resell, get home loans. I have several family members that are realtors, that are loan officers for mortgage companies. So I just think a deeper dive into that, and I would just like to see that again, not opposed against, but if we're gonna promote growth, I would like to see housing that's coming into Echo that's gonna be sustainable for generations to come, that'll be easy for people to get loans for. I personally, when we were house hunting, we found a property that was over 2 acres, had a manufactured home on it. We could not finance it because of how old it was, and it was past the date for however all that stuff works out. So again, with the housing in Oregon and the permits only on track to be at 31% of Governor Kotek's goals, I would just encourage, I think this is something that we need going forward, especially if we get to specifics of chapter 2 and the codes, because if you put in a whole development too, are we going into a manufactured or mobile home park, or are we going to follow the guidelines for putting in a manufactured home, which are different in the plan when you read it, and there's different specifications. So that's kind of where I'm at tonight on specifics, and so I would just thank you.
Thank you, Katie.
Can you provide that letter or that reference that
Yeah.
you provided?
I would send it to.
When I saw housing assessment, that shows.
Anyone else with questions or testimony, neither for or against? Yes, sir.
Jay Bales, 551 North Gilson. I guess at this point, I just don't care if it's for or against, but I do care about the liability that this cities could put on property owners with the danger of fire. Totally unfair, and I think it's just a litigation disaster waiting to happen. And we can talk about made up reasons why we should keep it open space. As far as I'm concerned, I got just as many people will say those urban legends and rumors are false. So 50-50, some of that stuff could happen, be true. But what is true is if something happened up there, the liability that myself and other property owners on that hill would have would be tremendous. And it would be something that I guess what I'm saying is the city should be on notice with that letter from Jennifer Bregan that they have some skin in the game on this, because it's not right not to handcuff owners, not let them to be able to do something to take care of that, and then expect them just to say, okay, fine. It's just wrong. It was wrong back in the 70s when they made that open space. It's wrong today.
Thank you, Jay. Okay, anyone else? Questions or not one way or the other? Okay, and we will move on to any of those in favor of the application wish to rebut the argument from the opponents. This time, you have your opportunity. We kind of moved on from that, Phyllis, but yes, you may approach the podium.
Phyllis Shabelsky, 221 West Main Street. I have two questions, actually. When there are some stipulations and guidelines as to when this grant has to be fulfilled, and I'm not aware what that deadline date is, so I'd like to be made aware of that. And I then have a question for Gina. When she says that so many people in Echo are opposed to this, I don't know if a survey's been done, but I know a lot of people that are in favor of it. And I just feel that the opposition is being far more vocal.
Thank you, Phyllis. I think you two should take it up together and not in, it's probably best not done on the record.
Yeah, it's time for testimony.
Yes, that's not necessarily testimony. So, yes, Joan, you had a rebuttal. Thank you.
My rebuttal was concerned with something Gina said in her testimony, and it was about not developing Echo. And in the development plan, the current one as well as the new one, there's housing development laid out, economic development and urbanization development laid out. That is the goal of Echo. So I just wanted to point that out, that the plan does talk about growing Echo, bringing businesses in, bringing in urbanization to help Echo continue to thrive and grow. So I think that if the goal is different than the plan, then we probably should redo the whole plan, and it wouldn't work. So
Thank you, Joan. Okay, last opportunity for rebuttal. Okay, let me buzz this thing off here. Okay, so now we will move into council deliberations. So, where do we start here? Yes. Oh boy. Sorry, guys, I've been planning for this for a week, trying to get my thoughts straight, and it's all in a big pile. So I think as a council, we need to start moving forward and making some head nod decisions. We can't make any formal decisions, but we need to take what we've heard from the public and what we've read and what we've been advised on from various sources and start deciding how to move forward so that we can either make some changes to what the PAC has proposed so that we can get that out to the committee, or not make changes to what the PAC has proposed, or additions or subtractions. We've heard a lot of testimony. It's all seems to be the same thing every meeting for the most part. It's open space, zoning. Really, 90% of it. And we've got passions on both sides. And we have lucky us, we get to make a decision on that. And there's going to be folks that aren't going to be happy with that decision. And there's going to be folks that are happy with that decision. But it's what they elected us to do, is to make the tough decisions. So I guess tonight, I could start with answering Katie's question she had about mobile homes and whether the subdivision would be a mobile home park or a subdivision with mobile homes in it and affordable housing. And I know mobile homes tend to be more affordable than stick-built homes. They are harder to get financing on, especially if they're old. Sorry.
There's a distinction between manufactured and mobile.
Oh, sorry.
Very big distinction. There's still no-
Manufactured homes, let me be very clear, mobile homes are the old ones that had wheels and they were left on wheels and had no building standards, so to speak, no foundation. So manufactured homes, now the state, and Carly, you might be able to help me out with this, but the state has specific regulations on manufactured homes, is that correct?
That is correct.
Okay, and our new proposed code And the old code addressed manufactured homes as well. And manufactured or mobile home parks. And I don't think that this is proposed, although nobody has sent in any paperwork to this effect. But from what I understand, it'd be 8,000 square foot lots. And they do this for a living and put manufactured homes on these lots and try to make them affordable, because that's what is needed across the state to meet that goal. How they deal with financing, I don't know anything about manufactured homes. So, but I think that our development code addresses those specific issues and would address mobile homes that go on a lot, as well, or manufactured homes that go on a lot, as well as manufactured homes that go in a park. And there's a definite difference between the two.
Yes, a park is very different than a subdivision.
Yes.
Yes, so in a park, you can own your home, but you're not gonna own the land it's on. That's where financing becomes difficult. When a manufactured home is placed on real property and it's placed with a foundation, and you own the home and you own the property, then the home is no longer private property, it becomes real property when it gets attached. So much easier to finance because you're financing a home and property.
Yes.
And again, the magical date is some random date in June in 1976 is when the law changed and how a manufactured home is constructed had to meet building code requirements at that point. So a park is a real different animal, has its own set of standards, and that is actually regulated much more by the building codes division than I realized. That's been an epiphany I've had in another community recently. As much as we think we have control over manufactured home parks, we need to be working really closely with our building official, because it is the building official who's going to make the lion's share of the decisions about how that manufactured home park is developed.
Okay. And I, for one, am aware of the governor's plan being hanging out at the Capitol and visiting directly with the governor in the past. And we have done a housing study. The last was 2019, correct? And so it did identify some needs. Yeah. And this council has discussed ways to, if a developer comes to town, to try to meet those housing needs on that surveyor plan that we've done. So we are, rest assured, we are working to help with that goal and get people housing as best we can.
To keep in mind, Mr. Mayor, that
Yes.
in that plan, and I'll get that to Katie, I'll just have Amanda put it on the website. It's been sitting on my desk for a while. It talks about a varied and mixed use in the community. So Echo has seen, well, since I've been here 7 years, I've only seen 4 places, and 3 of those were mobile homes. And one of them was a stick-built house. And so it talks about in that thing, just quickly, so to clarify a couple things to finish up what Carla's saying, is that there's the affordable housing that the governor's task force, or what she wanted to have her achievement for 36,000 housing units. And I think the state's only met 11,000 as of the last time I saw some statistic on it. But it's a prayer. Echo looked at affordable housing, which is not as much as we would like to say stick built so much anymore. Stick built is getting to be very expensive. So medium level and then higher level homes. So it hit all 3 of those categories and what it recommended. So keeping that in mind, and unfortunately that was done in 19, and the housing industry has changed a lot since 2019 as far as cost of building materials and things like that. And so I think we're going to see a lot more of those things in the future, Mr. Mayor, because most people can't afford $500,000, $600,000, $700,000 for a house. Where a manufactured home, you're looking at $350,000, $400,000 with 2-car garage, 8,000 square foot lot, which is what Mr. Hatley is proposing verbally, no paperwork, for that development down there to make it more affordable, so people can get housing. and I agree with Katie's assessment 100% that there are some drawbacks to certain things with mortgaging, but they do have processes for the new ones. It's the older ones, because I've looked at also trying to buy one and couldn't get financing. So totally understand what she's getting at. So that's all I wanted to make sure you understand on that, because there is a real distinction anymore. Building that beautiful, stick-built home that we all want, can't all afford it. It just flat out got outpriced us now in today's market. My son builds them, they're just expensive.
Any other discussion on that, guys? I just wanted to make sure that that question got addressed.
I have just a general question.
Could you use your microphone? I can't hear you.
I just have a general question, but.
We can move on. If no one else has anything on this, then we can move on to the next thing. That's fine. Yeah, okay, go ahead, Jesse. Sorry, I just want to give everybody before we move.
So I just wanna, and hopefully this will make sense to everybody, sorry if I go all over the place. It's been a long day at the hospital, so, I'm just taking in all the comments that's been going on for the past several months, and being on the PAC committee, and being on the council, living here since 1981, so 44 years. I'm just looking at Echo as a whole, and when I say that, I mean from the very beginning. And I'm gonna be the person who says it's very unpopular opinion. The Native Americans were here first, so let's remember that. And so let's remember that history too. And so when we came here and developed it from the Homesteading Act in the late 1800s, the early 1900s, that was a huge change for Echo. So when the railroad came through and the cattle station came through, it was probably more of a booming town than it is now, and things developed. I'm probably in the 50s, and after post-war, it's probably more booming. There was more businesses. I've had people who graduated like in the 40s and 60s, and through the years were like, Echo is so dead now, and all these buildings or businesses are gone. Growing up here, went to school in the 80s and 90s. Main Street was complete rundown. So I know the people who lived here long-term really value smallness and open space, and I really do too. I really love being out in nature and coming in and seeing these open spaces. But I really value what we have now with, the businesses that have came in and the families that have came in, and they saw the value in these vacant buildings that have been there pretty much my whole entire youth. And we have places to go in town. We had a grocery store when I was growing up in H&P, but now we have, historical buildings preserved and that are utilized that people could use in the community. Like, so I'm talking about the wineries and the corn maze, and those are great things to come to. So being on the PAC committee, there was really no talk about let's develop everything in town. Like, let's just get every square inch. I think people were just trying to understand, like, where are we at right now? How are we going to keep the feel of Echo, but also improve what we have? So we could, just keep it going, and also have money coming in for that, because we don't really have money as a city coming in. So when I keep hearing comments that we want to develop every single inch, I didn't really get that feeling from the people back. But I also want to, I want to honor, like, we all want to do right. We all want to honor the open space, but we also want to honor the property owners so they can do what they need to do. And so I'm all for open space, but if the city's only tool of having that, like along the canal, is to have the property on the hill, which goes with the private property owner, and knowing that any other time, those individuals could come in and be like, hey, 5 years down the road, 10 years down the road, hey, we want to just individually come in and say, hey, we want to use this space, not have open space. There's a process that could go through that. And if the city is just relying on that to keep the open space, I mean, it's not really sustainable for the city to keep the open space. And so if the people paying the tax dollars of the city of Echo really value the open space, I feel this is my question. How do we have a plan to maintain those open spaces they really want? Do we buy those properties that the city really wants from the private owners? Are we going to keep them paying those taxes? I mean, I don't know the answer, and I'm just trying to get questions out there. And I hope that we could have a plan sometime soon to go through that. And I think we need to plan now for how what we have now as a city and the revenue coming in, and also when we get more revenue coming in, that plan can change. Because right now, we don't really have a lot of, but how can we do it? If it's really that important to people, how can we do that? And I don't know if that makes sense, something that makes sense to people, but those are my questions, those are my thoughts. It makes sense, and you said it before, Carla said it, and I think it was the last memorandum, where she said if the city wants property to develop, or not develop, but to be designated open space, that we should seek that out and look into acquiring it for the city, so the city could use it, it could actually be used by the public, because right now, the open spaces that we're talking about, they're on private property, so we can't use it, they can't use it, it's basically, it's not useless, but it is, because no one can use it. Yeah. And so I think what you're saying, and that's kind of what you said a few weeks ago, I think, or a month ago, we had so many meetings. Yeah. That, I think you brought that up, and it makes sense to me, and what Carla said in the last, memorandum was, that is something that the city, if that's what we want to do, is to figure out what spaces we do want, and then to kind of come up with a plan. But then again, what you're saying is we don't have a lot of revenue or a tax base to do that as a city. So how do we go about it? Yeah. And is that going to be something in the development plan that we put down there? Is it not in, I mean, the development code, is that what that would be? Or is it a whole different thing?
I would not suggest, I mean, it's, so actually, one of your commenters tonight, talked about goal 5. And she mentioned several of the policies that are in there. That's your mechanism. Establish that public committee, and have them do that work. But at the end of the day, this is creating open space, is like creating parks.
Yeah.
Dedicating parks land, that is less a development code issue, and it's really more of it could be a municipal code issue. It could be an issue of a parks master plan. So there's more planning work. To assume that planning is done upon the adoption of these documents is short-sighted. This is really probably the beginning of planning work for the city of Echo, if you want to pursue things like this. Now, if you don't, then you can adopt these or not adopt these and be done and, go on about how it's currently happening. But if you want to have a path to identify what are the things we value and how do we acquire them and how do we protect them, that's another process.
Okay.
So I like to kind of add to that a little bit. So when,
He's the parks expert.
when Mr. Madison reached out to me a little while ago and informed me that he was going to talk to Jennifer and get a brief or a memo on behalf of the property owners up there, that spurred on the fact, well, okay, the city needs to also counter that with, not a counter, it's the wrong thing, get an opinion for the city. And so I reached out to Daniel Kearns, the gentleman that we used during the annexation that worked for the city on the city's behalf during the annexation of Northgate. And he was on vacation because I reached out to him right after the last meeting, and he just got back to me this week. He just got back from an overseas trip. And he and I talked about, I sent him all this information. I've overwhelmed him with emails. And so we talked about it for a great hour or so on Tuesday of this week. And he was not going to have time to get us a memo on behalf of, because I didn't think we were going to pass anything tonight anyway. So I thought we had a little bit of time. But since the conversation came up, we need to have, he saw Jennifer's proposal. We also talked about open space and the development code and the contradictions that are in there currently. And so he was going to give us some feedback on that too, on kind of representing the city, not kind of representing the city, for the council to review. I just wasn't able to he wasn't able to get that to me tonight to answer some of these questions that have come up and kind of address that. Because he addressed to me on the phone that it would be a good idea. What Echo has is kind of unique as far as it's been accepted since '78, but he also said, well, we want to make it an open space, so want to do it. The city should buy the property and make it open space. And so, and keep it that way. Or the other thing he said is like what they do in the valley, they have private property, and Gina's right, people that have private property with open space, but they have easements for, like Tammy was talking with me the night, a trailer or other things to go through those properties and then compensate those landowners in some fashion. Now, we didn't talk about compensation with SID, but the point is landowners, that's what they do down there in the valley is they compensate those landowners for those water walkways and stuff that go out through the farms. That the farmers still own those properties, but they got some compensation tax relief on those properties through a legal process. And so that was what he was kind of leaning towards, but he was going to think about it and then he was going to get back to me when he could. And it was kind of a broad conversation. So about the leading exactly what Jesse's talking about. He said he felt that the way it is now is troublesome, but all I'm doing is conveying that I don't have verbiage or I'm not a lawyer. So he felt it was troublesome and that needed to be addressed in a different way. And he wasn't advocating for one zone or the other. He was advocating that we need to change to make it say what we want it to say. And make it the way you want, the people want it. If they wanted open space, then somehow, some way through some mechanism, you need to do that.
Because it's only time before another property, I mean, people sell property all the time.
Correct.
And, you know, there are new people who live along down from when I've grown up, and even, you know, at the ridge, for 10 years, that lot was vacant. 10 years, I mean, something, this is a long time. So that was a golden opportunity for the city to buy a portion of it if they wanted, I feel. It's my own opinion, like, why didn't? We would have been more, the city would have been more secure in that versus just relying on that zoning for open space. So I feel unsteady about just relying on this, the zoning for the open space, to rely on that for the open, for, you know, nature space, but also for the residents too. It's not, you know, like the city really wants to be unfair to people also.
And I just like that, I would recommend the city consult with Daniel Kearns. He's a land use specialist, and I think he could provide you valuable guidance on these issues with his vast experience in the area. He's also a hearings officer for various different types of governmental entities like counties and cities. So he's got a vast experience on some of the concerns maybe Tammy has of processes and how these things are implemented that he could provide assistance on. So I would encourage that.
Well, and I think that, you know, this letter from Jennifer Bragger is quite an eye opener. I won't say it's a surprise necessarily, but it's quite an eye opener. When you really think about, I mean, I've lived along that canal, the upper canal, for 24 years. And the weeds, if I don't cut them down, they don't get cut down. They'll grow 4 or 5 feet, 6 feet tall. The sagebrush, which we all know burns really well, hot and fast. I've had to cut it down before as well. I don't mind the sagebrush, it's kind of nice. It's what we have around here. But you get too much of it and it's hard to put out. And we've had a fire along that canal down by Gary Martin's house 1 year, and it literally created its own weather. There was wind and the fire department had a very tough time putting it out. They did get it out without getting to any houses, but it was tough because it was so hot. The dry kochia, the dry weeds and the sagebrush and all of that. And I didn't realize what was an eye opener for me was how the code doesn't address open space. So Phyllis can't have a bunch of weeds in her yard because it could affect her neighbors and be a fire hazard. But those folks that are along the canal in that open space are restricted in what they can do up there. And those codes don't apply to them because of the zoning. So while the code may apply to Phyllis, and so then she has to, by law, take care of the weeds, the folks with the open space don't. And the city has no recourse. So that needs to be addressed as well as an additional thing that might have to get put in here, or, you know, depending on which way this goes. I love Jesse's idea of turning that into a green belt, let's say, right? You know, a lot of towns have that, a walking trail with trees and picnic tables and benches and, you know, things like that. Maybe an extension of the river walkway. But the only way to do that is for it to be owned by the public or leased by the public or an easement by the public. So those landowners are compensated. Most people assume, I think, even though open space can be on private ground, that open space is publicly accessible. And we hear of folks getting hollered at for being on some of those open spaces. Time and time again, so. Yes, Berlin.
I just, because of all of this, and it's walking trail, and I'm on that committee, so I kind of took a few notes. So we talked to, I'm just gonna key right all in, we talked to Sandfield Irrigation about using an easement for a potential walking trail along those 6 properties. However, the easement goes through all those properties, and according to our trail committee's handbook, private property will not be utilized without prior consent from willing landowners. Also, being on the trail committee, I learned a lot about breaking ground in Umatilla County, and there are a lot of regulations, and they put a huge emphasis on cultural findings. Because of this, if any one of those property owners did do any kind of development or wanted to break ground, they are going to be heavily, like, the agencies are going to be involved, including the ditch companies, all the, like, the tribes, everything. Like, there's so many things in place to protect all these properties and these things, and I feel like we're acting like someone's just going to start digging, which can't happen. And I also think that we're looking at the public open space on private properties and saying, I like to see the sagebrush, I like to see the grass, but we're not considering that private owner and what they want to do with it, or not do with it because they can't touch it. So I just feel like we're looking at it and we're deciding for them when 6 property owners, when Mike Fisher stood up here weeks ago and said all 6 property owners would like to see it zoned residential. No one has plans going forward, but that's what they wanted. I feel like we kind of just let that happen, and it's just been a fight over what's public, what's private, and it's confusing the way it's zoned. And I think that they asked, all 6 property owners asked, make it residential, make it cleaner. And then when we got this email from Jennifer, it makes it very clear that it should not be zoned the way it's zoned to me. But I guess I just feel like giving the property owners their rights and what they asked for, because this is the biggest issue we've been having and the biggest fight we've been having. And like I said, like, there's so many things in place. It's not like they can start digging. If we want to do a trail, we need to get permission or buy it. We can't just put a trail there. And I would like to see a trail there, but
It's basically there's a route,
yeah,
so that's like,
it's tricky.
it's not guaranteed forever to be open space.
Yeah.
We don't own it. The city doesn't own it. It's not really.
So what do you guys think about this? As I'm hearing you guys talk, I kind of wrote down a few notes. What if we were to zone it residential, if the council was to do that, then that would allow us to enforce the codes and protect the city from liability, as outlined in Jennifer's letter. We would be,
By enforce the codes, you mean resident would have to take care of the land and protect it from fire and all.
correct, they would be under the same, I don't know the number of the code, but the weed ordinance and the nuisance ordinance and things like that, that we already have in place for private property litigation. If we were to make it residential, those codes or ordinances or whatever the correct terminology is would apply to those properties, whereas they don't now. So when they got, yeah, that open space, yeah. Because you had that happen in Boardman, like I brought up at the last meeting, you had that open field, it wasn't open, zoned open space, but it was open field that ended up spreading to the 6 structures. And the same thing could happen up there. There's a lot of fuel that hasn't been taken care of. But if we were to enforce our codes, that, or be able to enforce our codes through zoning, then those folks would have to manage that. And then moving, okay, I just didn't want to hurt yourself. None of that.
Don't move to that.
And then have Jesse's idea where if we do get some development in town, we could have the money to go back to those landowners and say, hey, we would really love to have, or we're gonna deal with them in the interim until we can afford it or something, where the city keeps the weeds down, but yet the public has access to it, or, you know, who knows what, right? But form a committee to look into that so that we have a usable space for the entire community that achieves what everybody's looking to achieve. It keeps the open space, it keeps that natural beauty up there, it's usable for everybody. I don't know, it's just an idea that just popped in my head as I'm sitting here.
We all live here because we like the small communities.
Yeah.
I don't, you know, like, I don't know, I feel like that's. Yeah.
Yeah.
We all like the small communities, we're all here to fix it. Yeah.
So no, we do, and I live next to it, and I like not having somebody right behind me. But that's not necessarily my right to not have anybody there.
Mr. Mayor, can I suggest something?
Yes.
Yeah,
Sorry, Dave.
I'm enjoying these conversations and I'm part of the problem I'm just talking to. I wanted to make something clear. Carla and I, specifically me, I need some direction to, as you guys took through these talks, if you want to get some of these changes or ideas or thoughts into the work that the PAC did, so people could look at it and then give some feedback. We need some direction, because right now it's all over the board. I have no idea what to write down.
That's where I'm going.
I really have no idea what.
So.
We will at the next meeting, I'm sure. Correct.
I think at some point you need to direct staff to make whatever changes, if any, that you want made, right? For review.
Right, so that the public has time to review it as well.
Correct.
Yes, and that's what we need to start doing, is we need to start having these conversations and come to maybe we won't all agree, but if we get enough head nods, they're not official votes that are putting anything into law, but they would allow Carla to come up with make a change so that we can get that out to the public. So.
That's one of the easy ones.
Well, we're on this one now. Do you want to skip over this one and come back to it? Zoning, you want to go into zoning?
Well, not.
No, the
The
downtown
one that's
zoning.
the-
Okay,
Yeah.
so let's start with an easy
The one they
one.
all have.
I think this one will be a little easier. There's been discussion on changing the zones. Why are we changing the zones of the parks and the school and the ball field and the city hall and that? Okay. Schools are built in residential zones all the time. Makes sense because that's where schools are located, in the middle of residential zones, so everybody can walk to school. The golf courses are residential, contrary to popular belief. They're also recreational. They're all sorts of zones. They fit into just about everything. our comp plan has addressed and put. Oh, sorry, guys, if the crowd could keep it down a little bit, we appreciate that. We're having trouble hearing up here. That would allow us down the golf course can be zoned anything. But it would allow for the future, and it would allow, I also have to looking at the zoning map, and it would allow for houses along Golf Course Road, which that is, open space on the right side, as your east side of the road, as you're going up the hill.
Okay, yeah, no, from that.
I know, I'm just looking at somebody other than Dave all the time. I'll look at Phyllis. But, and that's not even on the golf course, it's near the golf course, but it's not even on the golf course, so why would that be open space? There's nothing there but a gravel parking lot. And that could eventually be developed into houses or something else, for that matter. So I liked Carla's idea, and what other towns have done is to dedicate those spaces. And I think that we should leave the zoning as proposed for the parks and the school and all those other, the government entities and whatnot, as the PAC proposed. But the council needs to, after this is put into place, make resolutions to dedicate those grounds as those uses. So that we go on record as saying, we don't want anybody changing this. Okay, Georgia Park might be zoned, it could be changed, anything can be changed at any time, right? Even if it's recreational, it can be changed and made to something different. But we need something, regardless of what the zoning says, that says, we want that to stay a park. End of story. So I think that this is something that if you guys agree with me on this, fine. If you don't, that's fine too. But we could tell Carla and the public that we're gonna leave it this way. And here's what we're gonna do to make it right.
I think the last meeting, Dave suggested that keep it how it is. Or I don't know if it was currently or how it was proposed right here, and then we can keep.
I was talking about the houses,
Yeah.
not this
Not-
property.
Okay.
Because I envisioned
Oh,
what was suggested and
yeah.
what was just said. You dedicating an ordinance or resolution that thou shalt be parks, thou shalt be
Yeah.
public open space or public space. The skate park shall stay skate park. And then we need to go through the process of getting that legally done, so it's skate park and not a row as it is right now, or a vacate, right, like it is currently.
Yeah, and then we've got to go back and that street right away that's through the middle of the skate park, we're gonna have to deal with that. You know, there are some things, some housekeeping items that we are going to need to address, and this is where that planning continues, statement comes in. So if anybody has a better idea than that,
Like that, we kind of talked about like the layers, which Dave said gets kind of complicated, but if we can dedicate spaces, then I think that I'm fine with the golf and the school and everything going, going as proposed, and then we dedicate. So people, because people are scared that we're gonna
Yes.
lose something. And
Yes.
so to make it easy going forward, but also to make it clear that we are not gonna lose the golf course, we're not getting rid of the school, to not gonna lose the park. I think that that's the best way forward, and so,
thank you.
my,
Yes, Tammy?
So I feel just a little bit uncomfortable because how many letters was it we got today that I haven't even read? How many letters in opposition? Listen.
Regarding that topic, regarding space. Well, we're not making a final decision, we're just giving direction to. Okay? So, what do you think, Jesse?
also,
The letters you have in your,
Yeah, but
just by the
also-
way, guys, the letters you have in your email are all in the stack. The only new letter was the one that came late from Mike Duffy and the one from Vicente Escalante, and neither one of those addressed the golf course zoning.
Okay, like, it'd be nice, also, if we get this 3 months, we can hash that out too. Keep moving forward, keep going with it, but.
But we need to move
say-
forward.
yeah.
We can read letters for
So I'm
100 years.
grateful. I'm like.
So, I mean,
I'm-
but none of these mostly address, and I read them all. I read them all 3 days ago.
I know it's different.
Only a couple of them came today. 3 came today. Jerry Fife, Vicente, but the rest of them all came when I put them in your packets. They got emailed out last week.
Yesterday, there's some letters that came in,
Yep, I've been getting it. That was from Gina brought in a bunch yesterday.
lunch yesterday.
And I emailed them all out.
Most of those were yesterday. So, yeah, I read them last night. And none of them address the parks or the golf course or the government buildings or any of that. There's
Couple of them
one that,
mentioned.
there's one that addresses the residential commercial. But we need to, we don't need to make a final decision on this thing tonight or even in the next month, but we need to be moving forward and make some decisions and get this stuff moved out of the way so we can focus on other things. Because we got a lot more.
So it's just kind of like another rough draft.
It'll update the rough draft.
You could still take into account the comments of those letters relative to whatever changes you're directing staff to make when you review it.
Yeah, when we review it at the next meeting, then if anything changes your mind, then you speak up then and say, well, you know, I kind of gave a head nod to this last time, but this came in and, I need to change my mind or I don't need to change. It's not a final thing. It's just gives Carla and Dave and the public kind of an inclination of where we're headed.
And we've got more questions, different questions. to ask.
If we have different questions, then we'll bring those up at that time. But we-
And the only other thing I want to comment on is that as far as changing, since we talked about the canal, I still believe there needs to be more language on the ditch. Because it's a bigger liability. than
Well,
the
let's stay with this for right now, Tam. Thank you. But we're not talking about the ditch. No, I'm just talking about the zone, just the zoning, not the open space zoning and not the residential commercial zone. All of the rest of the zoning, the school and the parks and the golf course. I think that's basically the government buildings. Yes. The open space and the residential commercial will be a different discussion. Okay, does that make sense? Okay. So Richard, are you? Yes or no? Okay. Jesse?
Yeah.
Okay, yeah. And Janie? Well, leaving the zoning as proposed by this pack for everything except for the open space between the canals and the residential commercial. No, the zoning's been out for
We haven't changed.
4 months. The zoning hasn't changed. The PAC recommended zoning, it got released to the public in May.
So all of these.
Except for we'll have a separate discussion on the open space between the canals, and it's another separate discussion on the commercial residential downtown district zoning. But all the rest of the zoning. Yes. And Maria?
I'm just not quite sure about the zoning. I mean, what we're talking about, the golf course. I don't think it should be residential.
Okay,
So would that be a no?
well, it'd be I guess.
But no,
Yeah, you understand what the plan is, what I'm
Because
proposing.
if the plan as it was written, the new one, that the golf course would be commercial and residential.
No, would be residential only, so that people could build houses around and do golf course addition. And then we would dedicate, the council, and we could do it at our next meeting. We could make a resolution, to dedicate that property to remain a golf course in perpetuity. The reason that the zoning map is even being brought up is because A, Echo's never had an actual zoning map. They've always used what the county's had. And B, it makes it simpler so that the one employee that you have that has to deal with all this can actually have time to deal with it. When there's multiple zones, it makes life much more difficult, creates significantly more layers of rules and laws and regulations, which from what I've heard, the public wants less of. And so this would achieve that goal.
Yes.
Yeah.
No, until I read the letters.
Okay, so we got 2, 4, 5 that say yes. So we have 5 head nods. Carla, just to keep that in there, but Dave, if we could, the next council meeting, add dedications onto that, or maybe not the next council meeting, the one after it, if it takes that much time.
Do you want a resolution or go through the ordinance process?
Whatever the most appropriate is, we'll research that.
Talk to Dave.
And whatever would hold the most teeth.
One of his fortes.
Okay, so now if you guys want to get on to residential commercial. I think that's where we were going, right?
Downtown.
Downtown. So thoughts on that?
We talked earlier, talking about taxes, talked about how it's taxed on use rather than on zoning. And we talked about how the zoning might be commercial, it might be residential. But we didn't talk about how the taxes are affected if it's commercial residential. If there's a choice. Does that mean that?
As I understand it, it would be the same, regardless of the zoning, basically, it's more what the use is how it's assessed.
Okay, so commercial residential really doesn't make any difference as far as that's concerned.
From what I understand, yes.
If I mentioned the FHA loan, and we talked about like having different language, and so those people would still like, since it's like, I don't wanna say layered, but it's commercial and residential. I don't know what the wording was.
We'd have to add, you're talking about adding language that would allow
Yes.
residences in that zone, as long as those residences are already there, and they can stay a residence as long as it originally was a residence.
Yes.
Okay.
Cause I remember her concern about that, and people getting loans
Correct.
for that because it's in a commercial zone.
Right.
But if it's a residence, it would still exist.
And if their house was to burn down, they could still rebuild it as a house because it was a residence.
Yes.
That's how I understood it too, yes.
On this, it makes sense, except for I still thought we wanted the report on loans for this. We were gonna check out before we made a decision.
Correct, and I said that I didn't do that, but I do know that I've talked to a couple people I've not talked to. I actually am going through a mortgage right now. I can call her, Sheena, tomorrow and ask her that, and I can send out an email. I didn't think about that, so I could ask her. But I have talked to other planners, other folks that do planning, and the language is gonna be key for any of that if it's an allowable use. And if it says so in the document, in the zone, it says it's allowable use for residential, commercial. What is the allowable use in there, and then it can be financed. But I'll call Sheena tomorrow and find out.
I would be comfortable with this as long as it can take the first time. And it also to the price. Then this is, yeah.
Reverse, yeah. I'll ask her that question tomorrow. I'll make this.
So Carla, could you come up with for the next meeting some language as to what that would look like? That we could add to that commercial zone to make that residential use permitted?
So in either the last, not this summer, but the one prior to that, at the end of it, I basically pulled your old residential, commercial language forward. What I would tell you is that it's a commercial zone that allows a house. So if
But
that's,
only if the house is there already.
no, the way it's written is it allows all kinds of commercial uses, and then it allows a house.
That's the
That's the current in
Correct.
residential. So if we apply that in the same locations that it's being applied today, that would be applicable for the homes or the properties on the backside of this block, these blocks, and on the backside of those blocks, okay? Doesn't address, and I don't believe your current code does either, although I can double check that, but it doesn't address the house, are there residential uses along Main Street? And if there are, what's your objective in retaining those and creating an allowance for them to be perpetuated?
Right, and that's kind of what we discussed last meeting, and I think that's what, correct me if I'm wrong, what we're discussing now is to make it a commercial zone. The whole thing,
You're thinking commercial from this street, Main, to the other side,
both full blocks.
okay, 2 blocks or both longer.
Correct.
And just take the proposed commercial language and acknowledge that a house that is in place could be replaced if damaged.
Correct.
Okay,
Like a fire or whatever.
So we do have some folks that have houses on Main.
Right.
And,
well,
they've been that way forever, even though they're in a commercial zone that's clearly, according to our current codes, says they really shouldn't probably be there.
Correct.
So, but this would protect those folks. Even more.
It would happen. More.
Well,
It would be black.
it would actually protect, yes, Richard.
What's the advantage of it being zoned, commercial over residential commercial?
I think it's about the purpose of what your objectives are. If it's zone commercial and you provide language that allows a home to be retained, replaced, whatever, then, you're respecting the current use. You're respecting the use that's been there for maybe 5 years or 25 years or maybe 75 years. But you're also preserving the ability for those 2 blocks to, over time, as Echo grows and as development comes, then those homes could actually be purchased by some future entrepreneur and converted into a coffee shop or a bookshop or something else because it would be consistent with the zone. So you can make the choice either way, but I think you can protect the homeowners through either mechanism.
The only reason that I kind of like the commercial residential designation is that plainly tells people that both things can happen. Whereas if it's zone commercial and they don't read the additional language, they don't know that.
Well, they're probably not gonna read it in the first place, actually.
That's what I mean.
Your lender will read it, or a developer will read it. So, if you're just buying a house, you're not gonna read it, or if you're living there. The trouble though with that is then you have an additional zone. You don't have quite the protections like Carla was saying. And then you have the folks on Main Street that are already zoned commercial, and their residences aren't permitted uses there, and they're using them that way now.
Right, you actually are creating a situation where if you leave the half blocks at Front Main as strictly commercial and don't acknowledge those residential uses in the zone, in code language, then should something happen to one of those homes, there wouldn't be a provision to replace it in the code.
Right.
So in some respects, I think you are more protective of those residential uses if you leave it all commercial and add to that language the allowance to replace and maintain a residence that's there.
So then you protect, by doing it, the whole block as commercial with the residential protection in there, you're protecting everybody at once with one zone. It's cleaner, it's easier, it's.
Right, and if you look at your current residential commercial zone, it's, I don't remember, I mean, there was like 30 uses in that list. And the 30th use was a house. So it is a commercial zone. And the way it is written, it is a commercial zone that allows you to have a house. So, I mean, it really is 6 of one or a half dozen of the other, but the clean way to protect any home that's in this 2-block wide strip would be to retain the commercial zoning and add to the current proposal the allowance for a home within that.
Yeah, it's much cleaner, is what I see.
It is cleaner.
I'd still like to hear the reverse mortgage for sure and the loan first, and then they would, if this is a home, they could resell it the home, correct? Resell it.
If the language is clear, yes.
So would you guys be okay with Carla coming up with some verbiage to add to that commercial zone that Dave could take to his mortgage people and run it by them and see what they say? Because if we have that verbiage ahead of time, then they can go, okay, now I know what I'm actually commenting on, instead of going, well, if you guys change it, well, maybe, depending on how you word it. Does that sound good to everybody?
Yeah, I might all over.
Jamie, is your head nodding over there? Well, it's a lot. It is. Right. So I think what I'm hearing from the council is that we're cool with that plan. So are you cool with making up some verbiage that Dave can take to the lender?
Mm-hmm.
Awesome. Okay, and we'll get better information next time. Perfect. Wonderful, guys. Good job. Okay, so now do we want to tackle open space? Do we want to do something else? I do want to say that it was brought up tonight that our current comp plan that we have now does state that Echo, our goal is to have moderate growth and urbanization. It does state that. I've read it numerous times in the last 3 days. I actually read it today. Our current one that we are currently operating under and have been operating under for quite some time. I hear a lot that we're trying to change everything, and the verbiage is almost identical in the proposed comp plan to that same verbiage. There's no change, moderate growth, moderate urbanization. We have added more protections for the golf course and things like that in there. But I just wanted to make that clear to the folks that are listening, that the old plan and the new plan say the same thing, as far as that's concerned. Last meeting, I'm going through Carla's memorandum, was brought up about homeowners association. There's no homeowners association. That's up to private subdivisions to come up with by themselves. Echo Heights has that. They're not in the city, but they have code that's rules that they have made for themselves to live by that are above and beyond the county's rules. So if housing development comes into Echo and wants to have stricter rules than what Echo has, then that's up to the people that live in those developments. It won't affect anybody else's house except for those that join into their little group.
Language brought up by the insurance company, what do you want to do with that? With regards to the.
Oh, the comp plan, yes.
07,
Thank you,
section
Dave.
4.
So
I need clear guidance on that. They want to know too.
it shall be city policy to protect the city from possible overflow from or damage to the feed canal and furnished ditch. That's giving the insurance company heartburn. I thought Hermiston Irrigation had heartburn over that statement too. They
Talked about it. I mean, I'm not gonna speak for Annette, but that's what I got from our conversation, is that, why is that language in there?
Right, and we don't have any coverage. The city doesn't,
Not for
but if
profit.
it was to break and we said we would protect the city, we don't have anything to protect the city.
Correct. Insurance wise.
So, I know that had some contention in the pack and, it makes sense on both ends. It's a nice thing to have in there to, warn people that, hey, if you live next to a canal, there's some inherent risk. But to be kind of the same type of thing of having that, we talked about development up there, you need to contact the irrigation district because if you're gonna build, they're gonna tell you that you're gonna have to do certain things.
That's not what I'm asking, Mr. Mayor. I'm asking you, this says that we're basically gonna pay people if the ditch breaks. And I honestly think it's a bad idea, and it's been a bad idea since '78 to have that number 4 in there, but that's my opinion.
And our insurance company.
And our insurance, it's not saying that we don't protect the ditch or anything else, it's that opening up liability by saying that if it does break or does leak, that we're somehow responsible to protect them. I don't,
Advise to remove it.
yes.
They did.
I just didn't know if they want to reword it or.
Well, if it's gonna get reworded, it has to be in such a fashion that it's a policy that doesn't put the city at risk for liability. If it's really a passion for members of the group to have that, they want us to protect folks, we can protect folks in different ways by information, but not by saying that if it floods, it's somehow, we're gonna be liable. That was their concern. And I mean, they're the experts in insurance. You asked me to check and I did, so.
I think it'd be better just to remove it. That would be the cleanest way to avoid liability.
I recommended that it be removed from the beginning. So,
I know you're rewording to notify people that not be liable for it.
well, again, you don't regulate in your comprehensive plan, so if you wanna add something that would, take some further action, if that would be in your development code, I don't have any proposal tonight off the top of my head. But Dave and I can talk about it, and we might have to come back with something, but I've had trouble with this policy from the first time I read it in comp plan.
Maybe we could just make a statement from the city council that the city administrator, if something ever happened next to a canal, somebody built, like they've already built and they know they see. But if somebody new builds next to the canal, let's say,
They can't build up against the canal.
no, not.
They're not allowed to.
I know, but close to it or something, you could just say, hey, we have a statement that the council just wants to let you know that these things can break. It would just be something that the city administrator would have in a file, that when somebody built next to a thing,
Well,
but it wouldn't, yeah, but it wouldn't be in here, it wouldn't be an official thing from the city, just be an FYI, information on canals, you can make a brochure that says.
did to manage the infrastructure of the canal, if they were.
Well, if they did that, then they're gonna be on, then those guys right there will be on.
Yeah, I say we're.
I don't think it's our responsibility to get in the middle, it's our responsibility to put people in connection.
I would recommend you don't take this. So is everybody okay with it being removed? There you go.
Thank you.
I think that's wise. I know, I've got all sorts.
There's also a policy statement that's right in that area, and I'm sorry, I don't have mine open. That talks about the retained and permanent open space. And so if you make the move towards, if you have that conversation about that open space between the canals becoming residential, there's also a policy statement that would also need to be amended or removed. I want to say it's number 7, but I'm not sure.
Number 5.
Number 5. Again, if you change the permanent open space,
We will have to change 5.
you would need to remove that policy as well.
Thank you. Okay, so I guess only other thing on here. The grant question that's proposed. So there was a question, I guess we're on to the grant thing.
Goes to residential, that developer will be required to be public street and a public site. That gets access.
Not, sorry. Okay, so the grant, there was a question proposed about the grant and whether the council was aware of the grant, the requirements, and if the council approved the grant. And some of us answered that we had seen the grant, and some of us said and answered that we never did see the grant until after we voted on it. And I just want to point out that when we get asked questions from the public, we need to do our due diligence to answer those questions accurately. And if we don't truly recall the particulars of what happened, then that should be our answer. Because a lot happens on this council, and a lot of time goes by where we may forget that something was sent to us, or we may forget that we looked at it, or whatever the case may be. But I have records here that show that the grant was discussed. Harley came and discussed it. And then the grant was actually sent as part of our council packet with the requirements and everything in it. And then that grant was voted on. And every one of us, except for Maria, because she wasn't here, but Dick Yoder, voted aye to accept that grant. And so I find it very concerning that Dave would be accused of not sending out proper documents to everybody when they truly were. And I know we were kind of put on the spot with that question, but let's make sure we're accurate when we answer questions. And let's make sure we read these things that we're voting on. We have a responsibility to make educated decisions. And when we don't look at what's in front of us and study it and read it, we are doing a grave disservice to the people of Echo. Are there any questions on that? If anybody needs the specific documents and dates and times, I have them. Okay? Does that answer your question, Jesse? Okay, then,
There's a follow-up question. for grants and
oh, sorry.
Phyllis Chavelle, I'm sorry, I'm just showing them. Thank you. Asked about the grant fulfillment obligations.
She did, thank you for catching that.
I would just add to what you had shared that, the grant had a deadline of May 31st. We have done grant closeout. So we are now operating beyond the grant timeline. So the grant has been closed. The grant does anticipate adoption within the timeline. For a number of reasons, that timeline slipped. We had communication with the Department of Land Conservation Development through that process. Our Eastern Region rep was participating in our CAP meetings. And so she knew what the timelines were. She knew what the issues were that had happened. And I know Dave had done a follow-up to request about reimbursement. I'm not sure where that's at. But I have not seen anything that would tell me that there won't be reimbursement based on, we met the grant requirements. We either have to have adoption or adoption-ready documents, and we submitted adoption-ready documents.
Adoption-ready documents is key, yes. We did submit adoption-ready documents by the timeline that they wanted. They would have rather had adoption, but they got what needed to be to meet the grant. And Dawn, I do believe Dawn has said that. I don't know if it was in public, but I know she's told me that we were okay on timeline. So does that answer your question for this? Thank you. Okay. Okay, so the last thing that I have, I think, unless I uncover another note, is the open space between the canals. And that's the big dog in the room, right? So who wants to start that discussion?
You hear about? That, I think, right, from the 50,
From Hermiston? Yeah, she was here tonight, but she didn't speak.
okay, that's what I was. That's, but
It's there.
it's there.
It's not recorded. That's why they didn't record it. That's what was confusing for us, is that SID is pretty easy to follow. Because the landowner owns the land, but there's an easement. There's an easement that's tracked and you can find it's recorded. There is nothing recorded on that, because there, but they do own. That's why we didn't know that. We thought it was an easement too. So we all have some fault in that. But it is, she told me it's very hard to find and it was never recorded. They just kind of built it.
So when we work to do notice, we use the city's been working to establish some GIS layers. And so we're working in those GIS layers. And the GIS layers don't pick up the canal, just like it doesn't pick up streets or roads. There are some other things that the GIS layer doesn't pick up. And even though there may be an underlying owner there, the GIS doesn't recognize it because it's not a tax law. So GIS is database, is functions out of a database. And so when you populate the database, you populate the database with tax laws. But the Bureau of Rec ownership is not a tax law. So the GIS layer, it doesn't populate in the GIS layer. Same thing with streets or roads. The other big one is it doesn't capture is railroad right of way. So those are just some things, again, as we use the GIS more and more, we just have to remember which properties and more importantly, which ownerships who own not necessarily property, but they own a right of way, are not identified in that GIS layer. and then make sure that you're capturing those when you're doing those.
And they're the bottom.
Yes, I believe so, yes.
Yes. Easy.
So the Bureau rec, the bottom one is 100 feet, 50 feet on both sides of the road.
From center,
From the center.
from center, 50 out, from center both ways.
Yeah, for a total of 100 feet. The Stanfield, is an easement, I don't know the events. But, that GIS layer does have the ability, so in the assessor's world, again, I try not to play in it very often, but they have things like A accounts and U accounts, they have these other accounts. So like if you lease your property, or maybe you have industrial property and Meadow Outdoor has put an outdoor sign on. Those other activities and the owners of those activities get identified in the assessor's records. And so oftentimes those things will show up, they will populate when you do that GIS graph. That's why the Stanfield Irrigation District, I believe, showed up in it, but the Hermiston one didn't.
Because they have recorded leases, and then they also own property. They own different pieces, but they don't own the whole thing, and a lot of it is privately owned with a permanent lease, with the easement. And those are recorded, so then they showed up. So live and learn when you go through that process.
Nice.
Sure.
Yes.
Be on
the spot on shit.
Yes.
Thank you.
You're welcome. When you pay property tax, you pay on 5 acres minus the open space, or 5 acres plus the open space?
I don't own any of the open space. My property abuts the open space.
Okay.
So the
You're
photos,
off the hook. What is your neighbor?
so my neighbor below me pays taxes on the entire lot,
Including the open space.
including the open space.
The tax doesn't differentiate the zoning on that, Mr. Stu.
It does not.
It doesn't?
It's all one lot with 2 canals running through the middle of it. Or not.
Or so, in some cases, there are multiple lots, tax lots that are up
So
there.
the tax situation wouldn't change if we changed it to residential.
Correct, because there's nothing on it that's, if they built on it,
Then those
they
individual
developed it, then
lots.
yes, then the tax would change, because now the value's changed.
But it's
Use
taxed
it.
on ownership, not on zone.
It's tax
Correct.
ownership. Correct, the zone doesn't designate the tax or the assessed value.
It can influence the market value.
Correct, but your market value, you're not taxed on market value, you're only taxed on assessed value. We're gonna all become assessors by the end of this too.
Well, there's been some comments made, and I just want to quadruple this out, is that there's been comments made that, you know, with the open space properties up there, that, well, there can be tax breaks. The only way there can be tax breaks on those, if there's a designation of wildlife zone or estuary or some other designation that it's been blessed with and is recognized as, then they can come back in, and there are some tax credit perfect things in Oregon that I've learned can occur. But if it doesn't not have a designation and we just call it open spaces, which is what we're exactly doing right now, and have since 1978, there is no tax differentiation. There could be if it was modified to be a wildlife refuge, or like out there off of Hoyle Road in LeGrand, you've got the wildlife viewing area. Those type of things, they conservation easements, those because they farm it. But then there's also hooping cranes that sit out there and people go take pictures of them. So that's how they get tax breaks on that. That's what's explained to me on that and how that worked.
Right.
Especially,
Coming saying that they do.
They do.
yes,
Yeah,
Correct.
they don't have a designation like David's saying that would allow them to decrease their tax. And there are some areas, my dad owns property that falls into this. He's got some ponds that the federal government put on his property for wildlife. And by doing that, he got paid by them, and he gets a tax break on that portion of his property. But it's also accessible by the public. Now, they can't cross private property to get to it, but if the public is on it, he can't kick them off of it. And so so he gets a break because of that, but these folks don't have something like that. The public doesn't have the ability to go on there unless they're invited by the landowner. Correct, if we had a plan and we had money. Yeah.
Okay, so if I'm understanding right, the tax situation really doesn't matter whether we change it or not.
Correct.
So that to me leaves the next problem, and that's liability.
Okay.
And if we, right now, if you own part of that open space, I would guess that it's your responsibility to keep it from burning down a neighborhood.
Just, not necessarily. There's no rule. There's no rule that states you must do that.
In fact, quite the contrary, because the way the open space language is current has read first since whenever it was originally adopted. I think Ms. Briger's memo outlines it well. The way the current open space regulations are stated, they are prohibited from managing the fire.
I have it in writing right here, if you'd like to, sorry to interrupt.
No,
The following uses are allowed subject to permitting procedures in chapter 4 and any applicable design standards in chapter 3. This is current code. Emergency measures necessary for the safety and protection of property. So only emergency measures are allowed. So if your neighbor's property catches fire and the wind's blowing your direction, then you can get in your tractor and you can till the ground to try to make a fire break. But if you cannot do that unless it's an emergency.
So if that's the situation and you've got a lot of bushes in there or whatever, you can't do anything to those bushes without the fire starting.
Basically,
Yeah.
yes. You can run livestock.
and just for clarity, that the development provisions she's citing are the proposed ones.
Oh,
And I want to clarify that we didn't change the open space language, but very, very, very insignificantly, mostly just to align with procedures, not with allowed uses.
Right. So the allowed uses are farming, including crop cultivation, truck gardening, or plant nursery enterprises and livestock grazing. So that would keep your weeds down, but you have livestock in the middle of town to do such a thing, and you'd have someone have to purchase the livestock and feed the livestock and manage the livestock.
Even goats don't eat.
Well, they eat a lot of stuff, but they run out of food, then what do you do? And then natural areas, including wildlife refuges, are the other permitted use.
And how does that change if it goes to residential?
Well, residential, then they could potentially develop it. They could put a shed on it.
And you,
They could put.
the
They could also,
liability would be the same as it is for your house now.
well, your liability would potentially increase if you didn't follow city code.
Except from the city's perspective, the liability would be lessened because the city would have the ability for somebody who isn't maintaining their property to require it.
Right, because your nuisance ordinance would kick in at that point. in
So if
time,
they
not
let
your
wheels
development
through.
code, But your nuisance ordinance would.
Right. And so according to Jennifer Bragger's email, the city is potentially liable before designating that an open space because of the hazards that aren't addressed.
was very, I thought it was very straightforward and clear. I appreciate her responding to Kent about his.
Now, that doesn't mean these people are gonna go pay these things. I don't think that's anybody's intent. But they would be required to cut their brush down and manage their weeds. That doesn't mean that the clear cut the whole thing. But they will have to have some sort of plan to prevent the spread of wildfire to their neighbors. And it's up to the city and to enforce that. So, yes, so,
We're,
well, I just answered the question. I'm waiting for the rest of the council to say.
How I feel about it, zoning doesn't make sense to me, how it's zoned, no one can use it, and it's a fire hazard, fire risk. So that's how I feel about it, but I know there's a lot of passion for whatever reason in that particular zone. And so I'm not trying to be insensitive when I say what I'm saying, I just feel like if Mike Fisher stood up here and he said what they wanted, we got Carla said it, and then we got an email from Jennifer stating it. The zoning doesn't make sense. It just puts the city more at risk. It puts those landowners more at risk. And so I think it should be rezoned, but I think you guys already knew that based on my comments. So I'll just make it very clear.
And
I'm just a little confused about the ditches with this Bureau of Reclamation. Can they build on that or can they not build on
can't fill the ditches ever. Not unless they cover them up like they do in Bend and Redmond and put them in pipe. And then they still have rules about that, but they put them on the ground.
we can't interfere with the easement.
that?
No.
But it can't stand, you know, but not with.
No, they can only go on that if they were to put something in between there, even a chicken coop, they'd have to get permission to do that from the ditches because they're digging and disturbing the ground that could cause an issue with leakage or future leakage. That's what. Correct, but then again, it's cost prohibitive right now, Tammy, excuse me, Council Liz, it's pretty cost prohibitive for anybody to do much of anything in there in 2025 as far as development, but allowing the zoning change, I think what I hear, some of you haven't said anything, is that there's the risk, what Jennifer had brought up that I thought about the fire multiple times, but this is much more clear to me, but is the fact that you can't build on those easements. When we did the pipes across there, when we went across and underneath, I spent a year, Councilor Williams, getting the permits to do that. We have a pipe that belongs to the city of Echo, it's 30 feet under the ditch. That took almost 15 months to get approved. And so it's not, and we didn't disturb anything, we went under it. So that's how much scrutiny is on that stuff. There's absolutely no way, if you get caught doing anything, you're gonna get crucified. Public or person. There's just no way, there's too much protection around those ditches. And the farmers will come unglued if they lose their water. So there's the customers of the water. So we don't want, nobody, I've never heard one person, not one of those 6 landowners or anybody is for or against whatever it is you guys decide to do about damaging the ditches. That's the last thing anybody wants to do.
And is it Brian from Stanfield? Is that his name?
Brian Anderson, yes.
So Brian talked to me before the meeting. I'm not gonna speak, but I'll let Dave know very clearly where we stand. And their stance is, you're gonna build there, you're gonna have to put it, you are gonna have to pay to pipe the canal. They will not let you build next to an open canal. In your story, an earthen canal, in your story. And they've done that in numerous locations, Hermiston, around, he said, we just had a guy take us to court over it and we just won. He has to pipe the ditch at his expense. Because we will not allow anybody to build with it. It's so many feet, they're not gonna allow you to do it without a pipe.
Most of these spaces on the ditch between here, Stanfield, Hermiston, they're zone farm, residential. Like, it's not just zone public open space along all the canals, like, it's zoned differently and they find a way to make it work and so it's not like this is the only zoning and we're being weird by changing it. It's just, to me, you guys know how I support it.
If we wanted the walking trail.
Yeah, but that's not gonna be as simple as what we originally thought. I learned in this process too. You get the easement from the irrigation district, we gotta get permission from each of the landowners, SID.
And that would be something that they could go to the landowners and say, hey, let's say we do change it to residential. Protect the city, help protect them, protect the neighbors. We go to them and say, hey, you know what? You got what you wanted here. Why don't you give us an easement so that we can have a walking trail? Why don't you let the public access that and enjoy it? I mean, I don't know, maybe, it's just a spitball, but that's future. I mean, we can, your idea is fabulous. It's one of the best ideas anybody's come up with to let the town enjoy that property. Yeah, it can still be private ownership, but why can't the city enjoy that and have it more accessible? Right now, there's signs and things that say, no, you don't go on. People still do.
I mean, I love it. I know there's things about that, right? You're not supposed to. But it's a great place to walk.
Yeah.
Taking what you're saying into consideration, are you saying it should be residential or?
I'm saying residential.
I know what you're saying.
I've been very torn on this, and it's been very hard for me because I have property that abuts it. And I like looking at it. I see fox, I see coyotes. I can't shoot the coyotes, but I'd like to. The quail are all over, although they're more in my front yard than they are along the canal, because that's where the coyotes hang out. There's a lot of wildlife. It's a nice view. I don't have anybody's roof to look at. I can see the football field, so I can watch football games from my back deck. If someone goes on there, that could probably mess that up. But on the other hand, I am one for private property rights. And I'm here to protect the city and the public. That's one of our main goals that we've come up with is safety. And I fear for that to catch fire and spread to either my house or my neighbor's house, which would be very easy because there's enough people to do it. Do I manage it? A little bit. Do I manage as much as I should? No, it's not my property, but they haven't yelled at me for being on their easement and running my weed eater. But I have to make a decision that is not based on my emotions. When I say that I have ex parte communications and they won't impact or biases that won't impact my decision-making, then I have to stand by that. And so with all of that considered, I have to do what I feel is right for the community and the city and the landowners, and that it would be to move it to a residential zoning designation. But I would like to see a plan put forward from this council as fast as possible to work with those landowners and work with the ditch banks to make that ground accessible and usable for the community.
And I would want to see the city say write a letter to all those people who own part of that and reiterate to them what the change means to them.
Yes. And that they now have to follow
And it probably should be attached to the title of your property.
well, it should have a copy of the code that would go with it. I mean, it opens up an opportunity for us as a community to have something very useful and protect the city. I don't want to see it go away. I don't want to, I really don't want to see it develop. I would rather it not be developed, but that's my personal belief. That's not the way the law reads or the liability reads or the lawyers would, or a judge would rule. But that's my heart speaking there.
Talk about house development, I have to look right at it. And I wanted to vote so bad because personally, I don't wanna look at houses. But for the community and for the town, I voted to approve and annex that in, and I stand behind that, even though personally, my view and all of my deer and turkey I watch won't be there, but it's gonna bring affordable housing in, and it's going to make this community better in the long run. So it's hard to not,
It is
to
hard.
not vote.
And if I didn't want, if I wanted to see open space, then I'd moved out into the county. I wouldn't have moved into a city. If I didn't want to see my neighbors, I wouldn't have moved where I have neighbors. I have that choice as a citizen. But I chose to live in a town that I love and is a wonderful community, full of wonderful people, even through this process and the names that I've been called. This is still a wonderful community. And I want it to remain that way. And I want it to remain that way for my kids. And hopefully my grandkids. So it's been a very difficult thing for me. It's a very long-winded answer, but I hope everybody can at least see where I'm coming from and not hope I have my tires on flat when we get up.
I'm gonna read, this before I make a decision. Like the stuff we do now,
It's fine. We're,
so we could.
it's been going on for quite a while. We haven't been able to do anything, so at least it's given us a few things. I mean, I spend over 40 hours getting the minutes done, so there's a lot of time spent on this, but yeah, that's fine.
Thank you.
For me, Carl and I can work on that.
I mean, we need to come to the next meeting be ready to make a decision, guys. We've kicked this can around town a lot. I mean, not a final decision. I don't want the public to say final decision, not a final vote, but something that we can direct Carla to do in the comp plan and the zoning to address this, that we can give to the public. It could, or it could bring up the same old stuff. I love my pretty trees, and I do too. I really do. I don't think people believe me.
So we'll get that done here as soon as we can, and then we'll send out the draft updates in those specific areas that you guys specifically talked about. I will work on a resolution / ordinance, whichever we decide is the best route for the dedication, and get that to you as well, but that'll be more of a council decision versus this public entity thing that we're doing here. And then, as soon as we get that draft language, we'll put it on the website and obviously email it to everybody that's on there and give people the opportunity to look at it before the next hearing that I'm assuming you're gonna schedule. So.
Yeah, and just remember, guys, if somebody does develop up there, they've got to put in streets that are a certain width. They have to have sidewalks. They have to have runoff space. It has to be accessible for fire and police. There has to be two-way traffic. And you're gonna build a house in between those two? I mean, that limits the amount of space dramatically. So just bear that, plus the easement. I mean, you start narrowing that sucker down when you start doing those things, so.
Could we, on the webpage, so we could direct people to it when you find out about the reverse mortgage and the loans? Could you write it up, a little spiel, and put it on the webpage, and then we could direct them to that information so that
That's a good idea.
it would be explained to them correctly?
Yeah, we'll just put it on the planning page underneath, got a little tab where we.
That would be,
Yeah, we could, but then that's where we'll put everything. And we've been putting it there since we learned we need to do a better job with it. So, yeah.
make a motion for another hearing.
Yeah, we need to look at the dates really closely, and I gave you guys calendars. I've got more of them here if you need a calendar to look at for,
Oh, and our regular meeting. Our regular.
yeah, the sixth.
Second. And nothing is on the 16th, which is the next after, we're gonna do it after the next meeting, but
So the second, or
I know, yeah.
how about the 16th? Or we could do it on a Monday. I don't, Gene.
Are we talking September or August? Thank you. Because August is, I can't do any of these in August. I'm leaving for a week to go get stuff in my home. I'm not gonna be here.
No, September.
Okay.
September,
second is budget up against Labor Day
it
weekend.
is, so we could do the 15th or 16th. Or we could do the second. Those work best for me.
The second doesn't work for me.
Okay.
The 15th or 16th works just fine for me.
Okay. Carl, how about your 15th?
Roundup is the 17th, I think.
Yeah.
Second full week.
Second.
Oh, is it that weekend?
Second.
Second full week. okay.
Second. So it's the-
Well, I don't know that how many of us are in the roundup, whatever.
Slack starts on Monday or Tuesday.
It does,
Oh,
yeah.
is it the week before?
It starts the kickoff.
So how does the 15th look for everybody? Monday, the 15th?
Monday,
Monday. Monday. Well, the first 10 minutes is me just reading that stupid thing.
I know.
I've heard that before.
For our next hearing to be on Monday, September 15th at 6 PM at City Hall.
Okay, so Berlin made a motion to leave the record open and continue the meeting on September 15th at 6 PM. Jesse has seconded. Richard, your vote?
yes,
Maria, your vote?
Yes.
Jesse, your vote? Tammy, your vote? Berlin, your vote?
Yes.
Janie, your vote? Okay, motion carries. We'll see you all in a few weeks. Thank you, everybody, for sticking around.